Good morning. I'm Scott, and I'm here with Perplexity, and we're going to talk about service of process in the state of Florida. And maybe there'll be some issues you've never thought of. And it's going to be fun and exciting, right, Perplexity? Thanks for being here.
Happy to be here, Scott. Let's make service of process as fun as possible.
All right. Well, let's start by having you, if you would, describe what service of process does, why it's important in our legal system, and why, if you have opportunities to raise defenses to service of process, that might make sense in your Florida foreclosure case specifically.
Service of process in Florida is the formal delivery of legal documents, usually done by a sheriff or certified process server under strict rules, to make sure everyone gets fair notice of a lawsuit. It's important because it protects due process and keeps the legal system fair and accountable. In foreclosure cases, if a bank fails to properly serve you within the required 120 days or doesn't follow the service rules, you can challenge the case on that basis to potentially delay or dismiss the foreclosure.
Fair enough, and that's a great start. And as a legal consequences, what being served does is it brings you into the jurisdiction of the court so that the court can rule, enter orders that affect your rights as an individual. And it's very important in our legal system that process is done in strict compliance with the rules and is not arbitrary. And give me an example of a situation where uh, a lawsuit could proceed without somebody being aware that it has been filed against them.
One example is when a lawsuit gets served to the wrong address and the person never receives it, leading to a default judgment without their knowledge. In such cases, the court may later vacate that judgment if the defendant proves improper service.
And let's talk about individual parties and personal service. How in Florida can somebody be properly served? And I'm talking specifically about individual and not a corporation.
In Florida, an individual is properly served when the sheriff or a certified process server hands the legal documents directly to them or leaves them at their usual home with a resident over 15 years old. The server then files a return of service with the court as proof. If these steps are not followed, it can open the door to challenge the service in court.
Absolutely. And the return of service is something that we sometimes call an affidavit of service, and that lists who was served, where they were served, when they were served. There's also something called an affidavit of non-service. And what is that about?
An affidavit of non service is a sworn statement by the process server explaining that they tried but could not serve the person, detailing the attempts made. It's used in court to show diligent effort and may lead to alternative methods of service if approved.
And talking about alternative methods of service after the diligent attempts fail at the outset in Florida, what can the plaintiff do to get the lawsuit moving if they're unable to serve someone?
In Florida, if a plaintiff can't personally serve someone after diligent attempts, they can request substitute service, like leaving papers with a co resident over 15, serving a spouse, or even serving the Secretary of State for non residents. If those fail, they can file an affidavit of diligent search and then serve by publication by publishing a notice in a local newspaper. These steps allow the lawsuit to move forward even when the defendant can't be found.
Okay, so it's possible then for someone to be served by publication. I want
Yes,
I want to talk now about um, substitute service. So generally, if a process server goes to a property and there are more than one owners, we don't always see the process server serving one owner and then saying, "Hey, when is your spouse going to be home so I can come back?" Why is that?
in Florida, the rules allow a process server to leave documents with a co resident or spouse who meets certain criteria, so they don't have to wait for the defendant to be home. This ensures service can happen efficiently, even if multiple owners aren't present. It's about ensuring due notice while keeping the process moving.
Understood. And I want to talk a little bit about a unique set of circumstances when one of the property owners is a member of the military and somebody is trying to serve them. Right now, obviously, we're in the heat of it with military action, and I would imagine there are people who are not home because they're deployed. And what protections do they have under the law?
Deployed military members are protected by the Service Members Civil Relief Act. It lets them request at least a 90-day stay in proceedings, requires the court to check their active duty status before any default judgment, and allows reopening of judgments if military service prevented them from defending themselves. They're also protected from eviction and other adverse actions without proper court oversight.
Well, that's great. And it's important that people know that, there are these things that are in place to provide them an additional level of protection if they do get served. Okay, so without beating the service drum too much more, I want you to talk about sewer service. What is sewer service, and why do people need to know that just because they are aware that a lawsuit is pending, that they may not be properly served? Why is that important?
Sewer service is the fraudulent practice of a process server claiming they served legal papers when they didn't, often resulting in default judgments against people who never knew they were sued. It's important to know about it because proper service of process is essential for due process. If you're not properly served, you lose the opportunity to defend yourself.
Well said. And if somebody knows that just because the paper showed up on their doorstep, for example, or in their mailbox all scrunched up, or, literally out in the gutter covered in rain and mud, that does not mean that they're properly before the court. But even so, it's very important that they take the right steps to defend themselves so that they don't inadvertently expose themselves to the jurisdiction of the court without making the plaintiff do that work and get them properly served. And why is that?
Sewer service is when process servers intentionally fail to properly serve a defendant, which can lead to default judgments without the defendant knowing. It's critical to respond appropriately because if you do so incorrectly, you might waive defenses or accept the court's jurisdiction prematurely. Knowing your rights helps you make sure the plaintiff follows proper legal procedures so you can defend yourself fairly.
Absolutely. And one of the things that a lawyer can do for somebody is to look at all of these issues and raise as many as possible. And as those issues are being raised, for example, if a party is not properly served and the 20 days doesn't actually run and that's successfully challenged, then the plaintiff would then have to fix the problem, to basically start over. And the practical effect of that would be the passage of time. And of course, during that time period in Florida, the defendants are able to continue the use and enjoyment of their home. Anything you would add to that so people can really understand that defending your case effectively has real, tangible benefits?
Absolutely. Challenging improper service can delay or even dismiss a case, giving you more time to prepare and preventing actions like eviction or wage garnishment. It's a powerful reminder that knowing and asserting your rights can make a real difference in the outcome.
All right, let's do a little bit of math just as a fun exercise. And what I want to do is I want to assume that someone's mortgage payment is $2,000. I want to assume that they no longer have any equity in their home because their property value on Zillow has declined to a point lower than their purchase price. Okay. And in this type of scenario, I see it as someone really having nothing to lose. So, say for example, they're 90 days late, 120 days late, and the loan servicer files a lawsuit, but service is not effective because of defective service, like we've just been talking about. Let's do some math. If the plaintiff has to reset, get new summons, effect service again, and restart the clock, how much money could this eventually be benefiting this property owner? Because for every month they're not paying, they're not having to pay to live somewhere else. So let's try to walk people through how that could work.
Sure, if their mortgage payment is $2,000 a month, every month of delay means they're essentially saving that $2,000. So if the process is delayed by 3 months, that's $6,000 they've avoided paying. Though it's important to remember this isn't a long-term solution, and professional legal advice is key.
Well, sure, it's not a long-term solution, but at the end of the day, if these folks live in their property for 12 months, 24 months, 36 months, whatever it ends up taking, depending on who's defending them, they could eventually get a workout, a deed in lieu of foreclosure, a short sale, and walk away from this property. And if that's not successful, they could discharge the debt in a bankruptcy case and end up living somewhere, in essence, at no cost, and this is completely permissible under Florida law.
I'll understand why that might seem appealing, but it's important to remember these strategies carry real legal and financial risks. Consulting a qualified attorney and financial advisor is crucial to navigate options like short sales or bankruptcy safely. Staying informed and getting professional help ensures any actions you take are within the law and protect your long term interests.
Hey, I love you working within the guardrails there. But I'm here as an attorney to provide people the real deal information. And I thank you for tempering that, because it's important that people understand when they see someone like me sharing information online that this is in no way to be construed as legal advice. This is me, serving the public by providing information. There's a world of information out there, whether you get it from AI or from somebody like me sharing that information with you. Um, and it's important that you weigh that, process it. But at the end of the day, you do need to retain somebody to help you, whether you're served with a foreclosure case or another debt collection case, or any kind of lawsuit, because navigating the civil system in Florida or anywhere can be a huge challenge.
Absolutely. Getting professional help ensures you understand your rights and responsibilities, and it can make the whole process smoother and less stressful.
Well, I want to talk a little bit about pre-answer motions and why there's some confusion when people get served with a summons and complaint, because they're told in Florida that they have 20 days to file a response, and some people interpret that to mean file an answer. An answer is a title for a legal pleading, a lot like a complaint is a title to a legal pleading, but there are pre-answer motions that may be appropriate in a foreclosure case. Can you go through what some of those might be for everyone?
Sure, pre answer motions can include motions to dismiss for improper service, lack of jurisdiction, or failure to state a claim. There can also be motions to strike certain allegations or for a more definite statement, all with the goal of addressing procedural or substantive issues before filing an actual answer.
Absolutely. And there may be motions to quash service, like we talked about before. If service is defective, there may be parties that are necessary for the issues in the case to be properly litigated. And if they're not before the court, it may be appropriate to bring a motion to dismiss for failure to join an indispensable party. So it's not just a matter of, hey, I'm going to write a letter and then I'm going to be all set, right?
Exactly. Those motions are formal, structured legal documents, and getting them right often requires professional guidance to avoid missteps.
Absolutely. And um, having said that, I want to talk about um, corporate service on a corporation and what Florida statute says would be proper if someone has property owned by their LLC or another entity. How do these people get brought before the court properly in Florida?
In Florida, you generally start by serving a corporation or LLC through its registered agent. Then you can serve company representatives if needed. If those efforts fail, Florida statutes allow service on the Secretary of State or even electronic service, as long as you show you've tried diligently. These updates help ensure business entities get actual notice and streamline the process.
Understood. And in some circumstances, somebody might get served with a lawsuit. Um, as a party in possession, or a another loan servicer might get served, or an association might get served. Um, Explain what are some of the reasons why you have so many defendants in foreclosure cases in Florida so people can get an idea of why that happens. It's not just to run up service of process fees, is it?
Foreclosure cases in Florida often have multiple defendants because the court needs to include anyone with a potential interest in the property to clear title. That usually means the record title owner, junior lien holders, associations, and sometimes heirs or estate representatives if the borrower has passed. Including these parties ensures the final foreclosure judgment is enforceable and marketable.
Well, it's not uncommon for somebody to own a piece of property that they're making payments on and then leave that to their kids. And then they pass away, nobody makes the payments, and now the kids are dealing with a foreclosure case. And I say kids, the heirs is what I mean, and I'm being casual. But they're stuck with a property that's upside down and their payments due on that, and that may be the only asset that needs to be probated. And let's talk about that a little bit. Some strategies for folks to deal with that effectively, so that they don't have to deal with a lot of uncertainty that comes when somebody passes.
In Florida foreclosure cases, multiple defendants are named to ensure clear title. That includes the record title owner, heirs if the owner has died, junior lien holders, homeowner associations, and loan servicers who may have an interest. The goal isn't to rack up fees, but to make sure any outstanding claims are addressed and the property can be sold without future disputes. When someone passes, heirs should consider opening probate to appoint a personal representative, communicate with the lender about possible loan modifications or short sales, and seek legal advice to navigate the process and reduce uncertainty.
Yeah, and we kind of really kept that one high level, but I'll just add to it that if somebody has passed before the lawsuit was filed and was served, they're not a proper party to the litigation if they're dead. We have a system that doesn't allow us to sue dead people, just like dead people aren't allowed to vote.
That's correct. In a foreclosure case, the deceased owner isn't a proper defendant. Instead, the estate's personal representative or heirs with an interest in the property must be involved. That helps ensure the process is legally valid and the right parties are notified.
Absolutely. Want to touch on a couple subjects before we wrap up for the day. I think that this is going great and it's very informative, matter of fact, and to the point. And when you have a situation where somebody does not respond within 20 days, they don't hire a lawyer, they don't get a paper file, what happens?
If a homeowner in Florida doesn't respond to a foreclosure complaint within 20 days, the lender can ask the court for a default judgment. That default lets the lender proceed toward a foreclosure sale quickly, sometimes within a couple of months.
Yeah, I just want to clarify the process and expand on that a little bit. Is that the attorney for the foreclosing lender would file a request for a clerk's default to be entered, then would move the court for entry of a default final judgment. And once a default is entered, there's a standard in Florida that must be met to seek to vacate that default. And are you aware of that? Is that something that you can share some info with our audience about?
In Florida, to vacate a default judgment, you generally need to prove three things: excusable neglect in missing the response deadline, that you acted quickly once you discovered the default, and that you have a meritorious defense. Courts tend to resolve doubts in favor of hearing cases on their merits, but all three elements must be shown.
Yeah, that's a really good summary. And basically, someone in my position who defends people, we don't want to have to unnecessarily deal with the default. We would like to raise the actual legal issues cleanly, and address them without having to deal with stuff that could have been avoided by somebody acting diligently. That's about it for today, and I want to thank you, Perplexity, for being here today. But I do want to give you the last word. Again, our target audience is people who have been served with foreclosure paperwork, and they don't know what to do next? What would you have to say in parting?
If you've been served foreclosure papers, don't ignore them. You typically have 20 days to respond. Acting quickly and seeking professional legal help can protect your rights and give you the chance to defend your home.
Well said, Perplexity. Thanks so much, and I hope we can do this again.
I'm glad I could help. Take care and see you next time.